So we are going to look at what we call the urgency relationship or ratification of the urgency relationship. So to start with, what does it mean when an urgency relationship is ratified? That term simply means that the principal, after the fact, approves or accepts any actions that are taken by the agent on their behalf, even though the agent initially lacked the authority to perform those actions. Ratification actually shows that they act with the owner, the principal. Agency relationships are explained, especially in a company law, where the directors or the managers of the business act on behalf of the shareholders who are the owners of the business. So the agents of the company are acting as if they're the owners, the shareholders of the business. Now, ratification in the context of agency relationship has a lot of implications. Number one, agency creates a legally binding relationship. So when ratification has been made, it now validates all the actions of the agent, making them legal binding principles. So when they're going to make decisions with third parties like customers, any transactions, the principal adopts the actions of this agent, like I gave a manager in the business as having authorized by them. The second implication of agency relationship is there's a consent to the agent's actions. So by ratifying the agent's actions, the principal, therefore, will provide consent for specific actions that are made by the agent. So this consent is very critical because sometimes it will create binding, enforceable actions such that the principal will be held liable for the actions that have been made through this agent. The other thing is that there's an assumption of the rights and obligations. So the principal here will assume both the rights and obligations arising from the agent's actions. So this means that the principal also be included in the benefits that are gained from the good decisions that have been made by the agent. If the agent makes good decisions that will profit the business, they will also be transferred to the principal. In fact, is the one who enjoys the benefits of the good acts. There's also a creation of a new contractual relationship. So ratification here also forms a new contractual relationship between the principal and the third party. So whatever contracts that the agent will have are essentially enforceable as if the principal is the one who entered into the contract. Liability of the agent's actions. So the principal is the one who becomes liable and responsible for the actions of the agent. So there's no retrogressive authority in the future to say, no, he was acting on his own. So ratification will also validate the past actions. So it doesn't confer retrogressive authority to say, no, at that point, this person was acting alone at this point. So it is important to take note that ratification is a valid legal term that is considered in law. Now, let's go to our compulsory question here. Dunstan is a businessman. He runs an electronic retail shop in Lusaka. Now, he wants to maximize on his turnover. He does both cash sales and hire purchase sales. Now, Chiwomba has gone to Dunstan's shop where he wants to buy a refrigerator. Chiwomba has found that the refrigerator he would like to buy. He likes it and he wants to buy it. However, the refrigerator costs more than what he has. So Dunstan tells Chiwomba that he can take advantage of hire purchase available in the shop. All he needs is to sign what we call a hire purchase agreement. So Chiwomba agrees. So he's told you can pay 30% of the purchase price and collect the refrigerator and the handbook together with the receipt. So the receipt includes all that the shop gives and the guarantee for a year and a warranty. So 2 weeks whilst using the refrigerator, it suddenly develops a fault and stops working. So Chiwamba is upset and believes the refrigerator had a problem all this while. That's why Dunstan gave it to him at a giveaway 30% of the actual price. So the 30% was just the commitment amount of the purchase price to get. So he is claiming that that's why he gave me that. So he wants to return the refrigerator back and wants his money. So he has come to you for assistance. So number one, define the contract of sale. Number two, distinguish warranty and the guarantee. And number three, state what credit sale agreement is and explain to Dunstan whether or not he has a right to return the refrigerator and seek a refund. So let's define what the contract of sale is. So what is a contract of sale? A contract of sale is a legal agreement between the buyer and the seller. So here where the seller agrees to transfer ownership of the goods and services to the buyer in exchange for consideration, which is usually money. So it involves an offer by the seller to sell and acceptance by the buyer, resulting in a binding contract. 2 marks. I repeat, what is a contract of sale? There are 6 elements that you need to know. Number one, it's a legal agreement between who? The buyer and the seller, where the buyer and the seller will agree to transfer ownership. So there's transfer of ownership for any good and service in exchange for a consideration. Consideration here could be money or time or payment in kind. So it involves consent where the buyer and the seller would what? Willingly accept, resulting in a binding agreement. Distinguish between a warrant and a guarantee. What is a warranty? A warranty is a term or condition in a contract that assures the buyer that the goods meet specific standards, okay, and have certain qualities. And it is a commitment regarding the state of the quality of the product and legally enforceable with a promise. So a warrant can be that if this particular commodity within a year gives you any problem, you can bring it back, we'll fix it at no extra charge. It's called a warrant. So a guarantee, on the other hand, is a promise made by the seller to be responsible for the performance of the quality of the goods and services if they do not meet the agreed standards. Unlike a warrant, a guarantee is an independent commitment, and a breach of the guarantee will arise to claim damages. So what therefore is the difference between a warrant and a guarantee? What's the difference from that definition according to you?
Well,
Mm-hmm.
in a guarantee, you're able to, since it's resulting in breach of a guarantee, so you're able to claim or sue. But in a warranty, I don't think that's impossible. It's also illegally, I don't see the difference. It's also a legally enforceable promise. So I'm not sure.
Okay, so sometimes in practice, there's a very slight difference in terms guarantee and warranty. Sometimes we use them interchangeably because they have a very close relationship. But we need to be careful that there's a slight difference in them. So the key differences are number one, the legal basis. Warranties are often governed by specific consumer protection laws and regulations, whereas guarantees are subject to the consumer protection laws, which may be more closely associated with a specific. Okay, so let me break down in another language what a warrant is before I get to the key differences, because this is carrying about 6 marks. Okay, so let's get to break it down. So let's start with the warrant. I'll say warrant by definition is a promise or assurance given by who? The seller
Seller.
or the manufacturer to the buyer regarding the quality, the durability, the performance of the product. So warranties can be express or implied. So express warranty is simply stated promises made by the seller regarding the product specific qualities and characteristics, what a product can do. The implied warranty are unspoken assurances of the product that it will meet the expectations of the performance. The duration, warranties can be limited or unlimited. So limited warranties have a specific duration of time, maybe a year, all right? Then enforceability, warranties are legally enforceable. So consumers may have the right to seek remedies or compensation if the product does not meet what it says. Is that clear?
Okay. Yes.
Then we go to what? Guarantees. That is a guarantee. So a guarantee, on the other hand, has the following things to take note of. Okay, so a guarantee is a formal pledge or assurance by the manufacturer or the seller to repair or replace or refund a product if it does not meet the what? The specified standards. Get the difference now? Then also,
Okay.
the nature of guarantees they're often explicit, made by the manufacturer or the seller to stand behind the product. So they may guarantee specific features of performance and customer satisfaction. So duration guarantees can vary in duration and may also be time-based, while others are ongoing. The terms of guarantee are typically outlined by the manufacturer or the seller. So enforceability, like warranties, guarantees are legally binding and enforceable. Consumers may seek recourse if the product fails to perform as intended. Now, the key differences between these two are in terms of the following. So number one, legal basis. So warranties are often governed by specific consumer protection laws and regulations, whereas guarantees are subject to consumer protection laws, but may be more closely related to the specific terms set by the manufacturer. Expressiveness, warranties can be both express and implied, whilst guarantees are only express. Terms of conditions, warranties may have detailed terms and conditions, including limitations of coverage, whilst guarantees only highlight features or aspects that are guaranteed with conditions of fulfillment. So in practice, warranty and guarantee are sometimes used interchangeably. There's a thin line between them. Okay. So that is what I can say in distinguishing them and justifying them. So state what a credit sale is. So a credit sale is an agreement or a contractual arrangement where the seller will allow the buyer to get what? Goods or services immediately, but defers the payment to a later date. So here, the buyer agrees to pay the purchase price in installments over an agreed period of time. So this arrangement often attracts some interest of the outstanding balance. So this is what we call a credit sale. It's a contractual arrangement where the seller will allow the buyer to take possession of the goods and services immediately after paying a certain sum of amount, but agreeable to pay the interest of the outstanding balances over a given period of time. Now, lastly, explain to Dunstan whether he has a right to return the fridge and seek a refund. So here, Dunstan, we heard the story. They have certain obligations and liabilities depending on the terms of hire and the nature of the defect. So here are the key considerations. Number one, the consumer rights. Number two, the warranty and guarantee. Number three is representation. He can use any of these cases. So consumer rights, Chihuahua is a consumer and may have rights under consumer protection. If the refrigerator has a significant defect or does not meet the promised standards, so Chihuahua may be entitled to a refund or replacement. Secondly, warranty. The fact that the shop provided a 1-year guarantee and warranty suggests that certain assurances were made regarding the quality and performance of the refrigerator. So if a fault is covered by these terms, Chihuahua will have a legitimate refund or repair. And also representation. If Dancer knew about the pre-existing fault and intentionally did not disclose it, so this would be considered as misrepresentation. So in such a case, we'll have a void contract, so you may seek a refund. So in conclusion, Dunstan should carefully review the terms of hire, warranty, and guarantee. So if there is a fault within the range of these arrangements, may result in the misrepresentation and may have a valid claim for refund. So legal advice can be sought in such circumstances. 20 marks. Is that clear?
Yes.
So I've talked about 3 things. Number 1, you need to review the consumer rights in that land that protect consumers. So if this defect is such that Tamoina gas completely, to a big defect that will cause harm to even the individual. There was a spark that would have been caused the what? An electrical fault in the home. So these ones will straight away be covered by the consumer protection rights. The second one is about warranties. Usually products that are new have a 1-year warranty. So that warranty is one that he can use also to say, look, it says within a year, if it doesn't perform according to what we have promised you here, bring it, get a refund or repair it. Then the last course of action is misrepresentation. You claim that this is a fridge that works very, very well. It refrigerates within a few minutes. It works efficiently, strong, it's durable. This is misrepresentation, so it can be sued for that. So these are the 3 causes under which Chihuahua can sue. Is that more elaborate?
Yes.
All right, so we go to another portion of law. 24th February 2021, Bell advertised a house valued for $2 million. The offer was open only for 5 days from the date of the advert. Charles called the company and was told that acceptance was strictly by letter, so he rushed the bank to secure the credit facility for the same house. So this was what? On 24th February. On 25th February, Panda Moyo, an employee of this company, Bell, met Charles by the mall and informed him that the house was bought by some investor. So Charles went ahead and paid for the house and sent the letter of acceptance since the offer was open and was assured of getting it. Required. Number 1, placing reliance on principles of contract law. Advise Charles on the legal issue at hand. Number 2, explain to Charles any 5 other means of terminating an offer. Let's go through the question again. So on the 24th of February, Bell Limited had advertised a house for $2 million. This was on offer for 5 days, so meaning month end 29th of February, it was going to close. Now here is a friend, Charles. He called the company, was told that this offer can only be accepted by later. So this same Charles goes to the bank. He secured the credit facility for this same house, and the following day, we have another employee called Banda. This Banda is an employee of Bell. So he meets Charles. He meets Charles. Are we together?
Yes.
Meets Charles, who is securing what? The credit facility at the bank. So Charles informed him that the house has been bought by some investor just to distract this Banda Moyo. Of course, he never wrote a letter. So Charles went ahead and paid for the house and later on sent his acceptance since the offer was still open. So now we want to look at what? no, on the second day, sorry, Banda Moyo, who's an employee of this company, when he met this Charles at the mall, he told him that no, this house has been bought by some investor. Now Charles still went ahead and paid for the house. And after paying for the house, he sent his letter of acceptance. Then also, since the offer was still open and he was assured of getting it. Now, let's answer this question. Placing reliance on the principle of contract law advised Charles on the legal issue at hand. Number 2, explain any 5 means of terminating the offer. So, advice to Charles, part A, and the legal issues. So Charles faced a legal issue concerning acceptance. So the key points to look at, number 1, is communication of acceptance. So under contract law, acceptance is only effective upon communication. So Charles was informed that acceptance had to be made by what? Strictly by the letter. But he communicated his acceptance through what? An acceptance letter. Now, what is a binding aspect of meeting Banda Moyo? So Banda Moyo. So Charles was informed by an employee, Banda Moyo, that the house had been bought by an investor. However, this information was informally communicated. So it was not a formal communication of rejection to say your acceptance, your letter has been rejected. No. Then again, reliance on assurances. Charles relied on the assurance that the offer was still open and that he would get the house. He went ahead and paid for it based on the assurance. So what advice we have to Charles? Now, Charles may have a valid argument for acceptance if he can demonstrate that, number 1, he relied on the company's assurance that there was no formal communication of rejection, because when the company had received information that the house was bought, they would have sent him an information which he did not receive. However, effectiveness of acceptance depends on the terms of the offer, if they're specified. In this case, what were the terms? The terms were that you need to write what? Through a letter. So you end your explanation like that. Now, explain to Charles any 5 other means of terminating the offer. Number 1, revocation by the offerer. So Charles now wants to know from you, who's taking law, how do I know that this offer was terminated? Number 1, the offerer should revoke the offer anytime before acceptance. So provided the revocation is communicated to the offeree. So the company was supposed now to write to Charles to say, no, this house has actually been bought. So this offer we gave has been revoked. Number 2, the acceptance could by default be terminated within the specified time. 29th February, by time being the passage, it would have been terminated on its own. The third way would have been the rejection by the offeree. If Charles himself explicitly rejected the offer, okay, or made a counter offer of the original, we would have terminated this offer. Then the third one is death or incapacity. So if either the offerer or offeree dies, then this becomes a terminated contract before acceptance. And lastly, fulfillment of the conditions. If the offer in subject is made by the offeree, or if the offer in subject is not made by the offeree, then the contract is terminated. So these are the 5 ways in which the contract may be terminated. Now, understanding these means of termination is crucial for individuals engaging in negotiations for understanding. So this is under offer and acceptance. All right, together? Are we following?
I'm following.
Okay. Following. So it is also important that you add also some case law in there. All right. So the situation here has been found is also governed by the Sale of Goods Act of 1893. So it makes clear that where a purchaser of goods has accepted the goods in a manner, they cannot reject this okay, we're looking at this one. So here the issue borders on revocation, what? On revocation of an offer. So there's a general rule that offer may be revoked at any time before acceptance. It can also be effective when the offeree learns about it. It is not necessarily that the offerer himself should tell the offeree that the offer has been revoked. The information may be conveyed by a reliable or unreliable third party. So the legal position was forfeited in a case of Dixon versus Dodds 1987, where the plaintiff was told a third party that the property had been sold to somebody else. Nevertheless, the plaintiff wrote a letter of acceptance, which was handed to the defendant. The court held that the plaintiff had heard about the revocation from the third party. So the offer was no longer available for acceptance. So no contract was formed. So in this case at hand, Charles had heard from the third party of such a contract and could not be formed as the other party was already revoked. So it was not possible to be accepted. So this is another way you could answer it. So you could look at the case of Dixon versus Dodds. So by the fact that Banda informed him as a third party, this was under the past precedence that was held in this case. So we can confidently say that this contract was void. So what are the number of reasons in which a contract can be revoked? Number one, revocation. This could be a form where part of the answer has been discussed above. For number one, rejection. So one can reject the offer, it is terminated. Number two, lapse of time, where time elapses. Number three, conditional offer, where an offer is made based on a condition. It terminates once there's a failure to fulfill that condition. Number four, a counter offer. So when an offer has been made, the original was made, then a counter offer has been made, then you revoke the original. Death, when parties die before entering into the subject matter, the contract dies. Acceptance. So acceptance terminates the offer because one person has accepted the offer. So there's no available offer available. So these are the possible ways in which a contract can be what? Can fall out of acceptance. Is that clear? Okay. So let's go to another question. Luwinda owns a salon in Northern Province. She's a sole proprietor of the salon, Luby Beauty. However, for the past few weeks, she suffered a toothache, which made it impossible for her to continue managing the business. So she went to see a dentist in Mongu, where she had a tooth extracted, but since then, she has suffered severe toothache. After several attempts at the same clinic to seek treatment, she developed an infection, after which she was referred to UTH, and she made arrangements to travel to Lusaka. Upon arrival, she decided to go to a private clinic, a dental star surgery, hoping to receive prompt treatment. She could not stand the queues at UTH, so she underwent surgery. Unfortunately, it resulted into damage of her alveolar veins due to the pain she suffered since the time she was in Mongo. So the money she spent and total bills in the hospital, her loss of profit in Mongo, Belinda Luwinda is now suing. However, she's not sure who to sue and under what course of action. So you're required to advise Madam Luwinda the following issues. Number one, explain who would be tortious liability, the Mongo Dental Clinic, the Star Surgery, Part B, since Luvinda suffered losses in her business due to her being a sole trader, advise her what business entity she can convert her sole proprietorship for assured continuity after her death. Then number 3, explain to Luvinda the difference between suing of tort law or law of contract. Then finally define an employment contract. Okay, an interesting matters there that are arising. So we can digest that. So let's go. So there are 2 main institutions that can be sued here. Firstly, the Mongu Dental or STAR. So in determining who is exactly liable, we must firstly look at the most important substantive and effective cause of Madame Luvinda's injury. So in determining the liability here, in law of tort, it is important to consider the issue of causation. So this is made by making connection between the defendant's wrongful conduct, the damage suffered, and if the damage caused by other factors could escape liability. So for the test, we could look at the case by Bennett versus Chelsea in Kenningston Hospital Management Committee, 1969. I don't know whether you know this case. So in this case, Mongo Clinic was liable for toothache suffered by Madame Luvinda, but the most effective and substantive cause of the damage to the earlier vein was caused by the Lusaka dental surgery. Hence, Madame Luvinda must sue Lusaka dental surgery. Okay. So secondly, the most appropriate course of action to pursue this action is tort of negligence, which is not taking care of particular circumstances as required by the law. So there are 3 main elements of negligence: is duty of care, breach of duty, and resultant damage. So this question was carrying about how many marks? 10 marks. Okay, let's go through it again.
I have a case to refer to when it comes to the tort of negligence. I think it has to be the Cassidy versus Ministry of Health. I can't remember what year exactly that was, but yeah, it was the Cassidy versus Ministry of Health.
Okay. What were the facts of the matter?
So Cassidy, is he called the plaintiff? He actually went into a clinic, a hospital, with 2 stiff fingers to go to be treated. And then after seeing the medical personnel, the doctor, he ended up walking out of the hospital with 2 more, which means 5 stiff fingers and then a damaged his hand. So it's said to sue the hospital for negligence.
Okay, great. So yeah, there are several cases that can be used. So I think that it's
I have
also,
to find the easiest one.
so you go for what you're easily able to remember. So in this, the context of a tortious liability, so both can be sued in another context and could be held liable, but for different reasons. So we start with Mongo Dental. If the severe headache and subsequent infection resulted in dental extraction performed by Mongo Dental, they might be held liable for medical malpractice or negligence. Because when taken to a medical care, you expect performance based on their expertise. So for dental star surgery, if the damage to Belinda's alveolar vein occurred during the surgery, at this surgery, they could be held liable for malpractice or negligence. So Belinda may also consult with legal professionals to assess the circumstances and gather evidence as to what appropriate party to sue. So also, as explained in the previous, you can cite a case from these ones here Bennett versus Chelsea.
Mm.
So then part B of the question was asking us to do what? Part B of the question was asking us to advise Madame Luwinda on converting her sole proprietor business for continuity after death. So which business could she go to? So the next business that she could consider would be a private limited company whose continuity is beyond death. So companies under Cap 8 of the laws of Zambia who retain certain advantages such as limited liability, perpetual succession, easier transfer of ownership. So by so doing, the business becomes a separate legal entity distinct from its owner and may continue to be in existence. So as a limited company, you must understand that when a company becomes a separate legal entity at incorporation and it has perpetual succession, it entails that it will outlive its shareholders even after death. Once the company has been incorporated, in effect, it is born. So the characteristic of the individual and what the company can do are separate. So Madam Ruby can employ people who can continue operating and enter into contracts and other entities whilst she's still bedridden. Therefore, the effects of incorporation will be limited liability. So if the members who go into losses, these losses will not touch her personal property. Upon winding up, the unpaid amounts of shares will go to the creditors. So the effect will mean that the company will have its own abilities, can sue and be sued, and can enter into an agency relationship where the managers will run the business on its behalf. So this means that the company will attain legal capacity to sue and be sued, and this will continue in the absence of Madam Luwinda. So what case do we use? Yes. The common case, the Solomon against Solomon Company, which is a practical case here, where a company has a legal entity. Okay, so we continue.
I have a question now.
Mhm,
In writing down, for example, we've explained
mhm,
the advice we give to Miss Luwinda, is it Madam Luwinda?
mhm.
So when you're trying to refer to a previous case like that, do you have to set the whole case?
No, just the case at hand. You don't need to cite the facts. No. I'm just asking you to know that you know what's happening.
Okay.
Explain to Madam Luwinda the difference between suing in law and in tort. So in tort, involves evil or civil wrongs where one party causes harm or loss to another. So this is under tort. It focuses on injury of a person. Suffered examples are the medical malpractice. And under contract, it's enforceable between two parties who entered into a contract of mutual understanding. So if there's a contractual agreement between the two, the clinics or the hospitals, there's a breach between the two, which may result into a contract being violated and a lawsuit can come in. All right.